Cause number DC 2419461, McLean Company versus Thermo King LLC. Counsel make your appearances.
Good morning, Maria Velarde for Defendant Utility Trailer of Dallas from Wilson Elser.
Paul Williams from Sharon, Callahan, Robson, and Garza for plaintiff McLean.
Barry Samad with Miller Knopf Law Firm here on behalf of Thermo King of Dallas LLC, otherwise known as Convoy Servicing.
Jonathan Spiegel on behalf of defendant Thermo King Intermountain, now known as Peak Industrial.
Javen Porter from Holland and Knight here on behalf of Utility Trailer Manufacturing Company, LLC.
Zachary Nye on behalf of Thermo King LLC.
Maybe is the plaintiff here? Plaintiff's attorney?
Yes, Your Honor, that's me.
I'm sure Williams. Okay, I'm sorry. All right. I read all the briefing. You may proceed.
Thank you, Your Honor. Good morning. Again, my name is Maria Velarde, and we represent the movants on the motion for summary judgment, Defendant Utility Trailer of Dallas. So the motion before this court today is based on the Chapter 82 innocent seller defense, Your Honor. Plaintiff McLean Company has brought suit today based on an incident that occurred in 2023 when a reefer unit it had purchased caught on fire while on the highway. For background, plaintiff had purchased a trailer with the subject reefer unit in June of 2017. It was invoiced through our client, Utility Trailer of Dallas, Inc., but installed by co-defendant Thermo King of Dallas. We have brought forth our motion today based on the fact that plaintiff has alleged the cause of the fire was a design.
Where are we in the discovery process?
Your Honor,
is the discovery deadline passed?
No, sir.
Okay. Has any discovery been conducted?
I believe we received discovery requests, but I don't believe we've exchanged so far.
You haven't even answered discovery yet?
Not yet, Your Honor.
Do the other parties, other defendants all stipulate that do they all, I guess, well, that's premature. Go ahead.
Yes, Your Honor, thank you. So again, plaintiffs alleging that the cause of the fire was a design, manufacturing, and or informational defect in the subject reefer unit.
I looked at your summary judgment. I don't recall there being any affidavits establishing any affidavits attached to your summary judgment. Is that correct?
Your Honor, I believe there was. I believe it is exhibit. Give me 1 second. I'll let you know what exhibit it was.
It's exhibit 4.
Okay. And who is the affidavit of?
This is for, I will tell you their name exactly. Robert Watson, and he was a sales manager at Utility Trailer of Dallas.
And has he already been deposed?
No, sir.
Okay. Have you given the other side the opportunity to depose him?
They have not requested his deposition, but if that's something they were interested in, that obviously would make our client available.
Right. But the discovery, you haven't even exchanged discovery yet, right?
Not responses, sir, no.
So you haven't even provided them your responses to discovery, correct?
No, sir. Yes, that's correct.
Have you provided them initial disclosures?
Yes.
You have provided initial disclosures, okay.
I believe
Mr.
so.
Williams, did they provide you initial disclosures?
Yes, sir. About 2 weeks before they filed their motion for summary judgment.
And okay, go ahead.
Thank you, Your Honor. Again, plaintiff is alleging that the cause of the fire was a design, manufacturing, or informational defect in the subject reefer unit, and as a result, they're asserting causes of action of strict liability and negligence against the defendants. However, again, our client, Utility Trailer of Dallas, cannot be.
If you can't tell kind of where I'm going with this, that there's two possible outcomes here. One, I deny the summary judgment, or two, I continue the summary judgment until they have a chance to conduct discovery. wise attorneys a lot of times say, hey, look, I want to give them a chance to connect discovery so that they have an opportunity to see that my client's not appropriate defendant. Sometimes having that in early, I understand the idea of doing an early summary judgment sometimes. I don't think it's appropriate in this case. But I can rule on this today, but it may make it more difficult you getting a summary judgment in the future if you already have one denial kind of on tap, if that makes sense.
Okay, Your Honor, if you believe that the best course is to continue it,
No,
I'm
that's
not.
that's not what I'm saying at all. It's your decision.
I understand. Well, Your Honor, I guess let's go move forward and continue it.
Continue the hearing or continue the summary judgment to another day?
The summary judgment to another day.
Okay. What do you think, Mr. Williams?
Your Honor, I mean, we talked about this in our response. They're basically moving for summary judgment on the basic issues in the case. So we're going to have to do discovery, not only from them, but also from every other defendant, because simply put, they're saying it wasn't us. In fact, I think what they say in their motion is that it was Thermo King of Dallas. I'm sure Thermo King of Dallas is not going to simply agree to that. And they might even say, no, it wasn't. It was Utility Trailer of Dallas. So what we need is all the discovery in order to do this. So I would say we need to continue this until after discovery is done, which we don't have yet because we don't have a scheduling order in this case, and we don't have a set of deadlines because this case is so new.
Yeah, you're right. We don't even have a trial setting. Is this a level 1, level 2, level 3 case?
It's a level 3 case, I believe.
Let me see.
Let me go back and look. I should know that.
I think you played it as level 3.
Yeah.
Well, so let's talk about that. Since we have all of y'all here, we could just talk about when y'all want to set it for trial, and you guys could work out a scheduling order, or I could put you on a formal scheduling conference date.
My position is we ought to give it a shot now, but I'm not speaking for anybody else here.
Judge, I think the best use of the court's time and everybody's time is probably for somebody to take the lead in drafting something up and circulating it. I think counsel can agree on dates if you're okay with that.
Well, so we have two ways we could handle this. We could pick a date for trial, not all the other dates, just the date for trial, because that's all I really care about is the date for trial. And then you guys work out the scheduling order from there, or I'll set you on a scheduling conference docket, and then you'd have to come back, probably on Zoom, but come back on Zoom to, work all this stuff out. And I understand if you want to do that, but I'm going to do one or the other, put it on a scheduling conference docket, or we can pick a trial date and a mediator today, whatever you prefer.
Well, Judge, I'm leaning toward picking a trial date mediator today, personally.
What does everyone else think?
That's fine with me.
That's fine with me.
Yeah, we're not opposed, Judge.
All right. How does, this is, well, yeah, so maybe March of next year, February next year. You want something sooner?
That works for us, Your Honor.
Your Honor, I mean, not that I have a problem with March or February. I think we could get it done sooner. I would like something before the end of the year, but if that's if I'm choosing between March and February, I'm choosing February.
No, I'm okay with. You indicated you needed some discovery. I'm okay if everyone agrees to like December. I wouldn't do before December, but if everyone agrees to December, I would be happy to set it in December if that's agreeable to everybody.
Judge, Jonathan Spiegel here for defendant Thermo King Industrial. I think February, March is better. I mean, we're about to head into the summer months. You know how that works with a multi-party case. In February, March, maybe February, other than before March, because I guess in March we're getting into spring break.
Sure. You want to do like February 3rd? Does that work for everybody? We start trials on Tuesday.
Yes, sir.
Yes, Judge.
Yeah, that could work.
Yeah, I don't have any objection to that, Your Honor.
All right, Rhonda, go ahead and set this case for trial on February 3rd. And who do you want to use as a mediator? And I tend to prefer to appoint Dallas mediators.
I mean, my first thought, Your Honor, was someone like Chris Nolan, but I don't know how anybody else feels about that.
He's an excellent mediator, but is this really a commercial? He does mostly commercial. Is this, I guess, I don't know. It's up to y'all.
It's, yeah.
This is really more product liability. You know, gosh, there's several good folks at Gilbert Mediation.
Y'all use Mark Gilbert, Martin Terry, Ken Ruben. I know he's not there, but Ken Rubenstein, Jim Jordan, King Pfeiffer, Courtney Bass.
Judge, I like Mark, and I think even though he books up early, I mean, February is still a far ways off, and
You probably want to contact him today to see if you can get something set by the end of the year is what I'm hearing. But
Yeah.
right, and then we've also had good luck with Jim Juno.
I've heard great things about him. He
And
might be easier to schedule with, but it's up to y'all. What is everyone, Mr. Porter? What do you think?
Yeah, all of those guys, I like them all. I've used, I think, the first guy, Nolan, first, but that's fine with me. So I'm open to that.
Ms. Valverde, what do you think?
Likewise, Your Honor.
Okay, so do we want to go with Gilbert? We want to go with Juno? Do we want to go with somebody else? Do you want to go with Noland? I mean, I like Noland. It just this doesn't seem like his kind of case, but
Yeah.
Judge, I think Mark Gilbert will be fine.
Yeah, that's good with me.
Yeah, I don't have any objection to Gilbert. I don't know anything one way or the other about Juno, so I can't.
Mr. Nye, Mr. Ahmed, Ms. Valverde.
Gilbert's fine with me, Your Honor.
Yeah, no objections to Mark Gilbert, Judge.
No objections to Mark Gilbert.
All right, let's go ahead and appoint Mark Gilbert on this. I would literally contact him today though to try to get it set up because I've heard in the past at least it's like takes 7 months to schedule with him, so you want to get him. Wait, I don't know if it's that bad, but I've heard stories. So
no, that's true. He books up early.
Yeah. All right, guys. I'm glad we worked everything out, and you guys have a great rest of your day. Okay.
Your Honor, sorry, I just wanted to understand, what did we decide on the summary judgment? Is it
It's
continued until after discovery?
It's continued until some future date.
Okay. All right, Your Honor.
We'll see. I mean, I don't, and let me just say why I say that is that I don't know when the scheduling deadline is. If you don't conduct any discovery and you just sit on your hands, I don't necessarily, I don't think you're going to do that, but it isn't always the case where I make them wait till the end of the discovery period. So,
Okay.
so you need to diligently conduct discovery on this.
Okay, we will do so, Your Honor.
All right. Thank you, guys.
Thank you, Judge.
Your Honor.
Thank
Appreciate
you,
it.
Judge.
All right. I think there's some folks here for the trial setting for tomorrow. Is that right?